a good logo designer will wait until the company goes to market before they put it on their website. I've seen that happen multiple times where the owner of the company is having this big reveal party, coming up in a month or two, right? They're putting a ton of money into marketing, branding, ready to go. And then their logo developer just kind of, post it on Facebook.
Whoops.
Right?
Whoops.
The branding.
Yeah.
So that's not, we don't want that to happen.
If it's misspelled, does that invalidate the whole patent? The answer is no, thank goodness. You can correct a patent with a certificate of correction, and that's through the MPEP section 1480 for those that really want to know. The cool thing there is, so long as it's not you are on purpose about it or defrauding the patent office in any way, trying to trick, the office that you're somebody else, and then, oh, nope, sorry, I made a mistake. They'll make you attest that there is no fraud involved. It's usually not a big deal for individuals. It may be more of an issue if the name of the applicant is a company. There may be some more things involved with that.
Yeah, I'll tell you, if the name was misspelled on the trademark, you are in trouble.
Ooh, tell me, would it be just you would not have registration or be owned by some
You'd be registered with the wrong name, right? Which would be a problem. Okay. So I've had that happen once in my career where we submitted an application with a misspelling error in it. And then we went to go submit the specimen, so the proof of use for the application, right? And the examining attorney noticed that they were spelled slightly differently. But the good news there was that because it was just like a one vowel change, they were able to amend the application because it didn't have a commercial impact on, people viewing.
So it was still an application.
Yeah, so okay. It was still okay to change it at that point.
Oh, I just got under the wire. Well, that's good, but yeah,
Scary though. Yeah, I thought I was going to be eating the cost and refiling.
I have a design consisting of a drawing with the phrase I want to sell on Etsy. I kind of want to trademark the phrase, kind of want to, and it's unique and could be the main feature of my brand. If this business is successful, however, I know it can take up to a year at least to get something trademarked, registered. In the meantime, how can I sell my design in a way that lets people know the trademark is on the way to deter them from stealing my phrase? Is it risky to do, or should I just wait?
Yeah, no, good question. So as soon as you submit that trademark application to the United States Patent and Trademark Office, you have pending trademark rights. So you'll have a application serial number at the USPTO, and that application is basically going to just hold space for you until the trademark registers. From a user standpoint, from a trademark owner standpoint, use the TM symbol, right? That kind of alerts people that you have pending trademark rights or you believe you have some sort of unregistered trademark right. And then ultimately, when you do register, throw the circle R on the branding and go from there.
About the differences here between, and this is on the licensing side, between exclusive patent license agreements and a non-exclusive one. It's a great question. And I will say right up front, we don't generally work on, licensing agreements. We just brought on an attorney that does some of this. So we don't have a whole breadth of experience. We usually focus on just getting bold patents, right? But when you get into a licensing agreement, the cool thing is with patents, you get 4 big rights: the right to make it, use it, sell it, and import it. So you get to prevent anyone in the country from doing those 4 things. And so you get to license those 4 if you want, transfer the rights to another party or multiple parties. So exclusive really just means you're locking in on one. You're saying you're the only manufacturer that is going to be allowed to use or to be allowed to make this product in the country. If you do that, you're putting a lot of eggs in one basket. And so I would say, you can help me with this, but I would say you want to make sure there's a performance clause that if they decide to shelf this and not make it, you're going to be able to get out of the contract and just watch it. You have to manage it more. The big upside with exclusive is that usually they are on the hook for infringement protection. So if there is an infringement down the road, they may be able to, contractually obligated to help you enforce the rights. Because they're really vested too. You're the only manufacturer that's able to sell it. Non-exclusive, as you may guess, is where there's not an exclusive deal. You have multiple manufacturers, multiple retailers, and you can still make royalties from any of them. So that's the main difference there. Matt, anything on the trademark side to mention?
No, very similar, in the sense that exclusive license, you can license the brand to just one group or one individual. And then if you have a non-exclusive license, then you can have multiple sellers or users of the brand. Yeah, same thing.
If I make a logo for someone and it's for their business on the clothes they sell, is it a one-time fee to buy the logo, or can it be a small percentage of each piece of clothing sold? Someone trying to get royalties.
Yeah,
What does that look like?
I really, this question all the time. Get this all the time, right?
Right.
And typically we're going to be defending the trademark owner, who in this case would be the business that's selling the shirts, right? And we are going to be trying to lock in some sort of agreement for the individual who made the logo for them. You can structure this however you want to structure it. You know, it's a free country, last I checked. And is if you have a contract that says that you get 5% royalties, you know, for any sale, then that's the contract. Generally speaking, when you create a logo for someone, they pay you money and you give them the logo, and you typically will sign them all the intellectual property rights of that logo.
Right. I'm the artist, and you're buying that.
I'm buying it from you, and I'm not just buying the rights to use it. I'm buying the intellectual property rights. So it's no longer yours; it's mine, right? And that's called a work made for hire agreement. And it's a contract, part of contract law. And yeah, I advise any client who's getting a logo created to make sure that you are entering into a work made for hire agreement. A legitimate logo developer, maker, will have a contract that will specifically call out a work made for hire agreement in the agreement itself. If they don't, I would have real concerns about using that individual to create a logo for my business. Yeah. You know, if you went with like a company like 99 Designs, if people are familiar with that, that's like a online third party website. I've gone and looked at their legal services agreement, and you do have work made for hire protection.
There you go.
Like that.
Good stuff.
Yeah, and then a last thing I will say too is typically, you know, the artist is going to be able to display the logo in their portfolio. You know, that's pretty standard. That, you know, if I'm a logo designer and I want to kind of show off some of the logos I've done for clients in the past, then, you know, they typically have the right to display that logo as, you know, evidence of what they've created in the past. However, you know, a good logo designer will wait until the company goes to market before they put it on their website. I've seen that happen multiple times where the, you know, owner of the company is, you know, having this big reveal party, you know, coming up in a month or two, right? They're putting a ton of money into marketing, branding, ready to go. And then their logo developer just kind of, you know, post it on Facebook.
Whoops.
The branding.
Yeah.
So that's not, we don't want that to happen.